The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good afternoon. Welcome to council and to all of those watching on our Supreme Court Live YouTube channel. I will ask Mr. Doug Shima, the clerk of the appellate courts, to please call the 1:30 docket.
Thank you, Your Honor. May it please the court. The 1:30 p.m. docket for Thursday, April 1st, 2021 consists of one case, appeal number 120387, in the matter of the tax appeal of River Rock Energy Company for the year 2016 in Labette, Neosho, and Wilson counties. This is a tax appeal with briefs on both sides. This case is scheduled for 20 minutes on each side. The first appellee petitioner, Kansas Department of Revenue, has reserved 3 minutes rebuttal time. The second appellee petitioner, Neosho, Labette, and Wilson counties, has reserved 3 minutes rebuttal time. Your Honor, we are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please enter your appearances?
May it please the court, the Kansas Department of Revenue appears by and through counsel Shelley Woodard and Jay Beffert, and we are present and ready for arguments.
Trevor Wolford of Morris Lang, Topeka, appearing for appellee counties.
It please the court. Keith Brock appearing on behalf of River Rock Energy Company, and also Stephen J. Moriarty solely in his capacity as Chapter 11 trustee for Post Rock Energy Corporation. Present and ready for argument.
Thank you, counsel. We will begin. Ms. Woodard, you may make your argument with your split time and reservation of rebuttal time. We'll set the clock for 7 minutes for that, and you may begin.
Thank you, Your Honor. This case is an appeal of the valuation of certain gas leases for property tax purposes. The taxpayer River Rock purchased over 2,000 leases in Kansas at a bankruptcy sale. After their purchase, they reviewed the property tax assessments for the leases and perfected the appeals on roughly 200 of those leases. During that review, they found that some were valued using a minimum leasehold value, and it is that valuation methodology that is at issue today. And so today I'm going to talk to you about how the minimum leasehold value is a reasonable part of the method of mass property appraisal and follows Kansas statutes. It has been part of the Kansas appraisal methodology for over 50 years. The minimum leasehold value reflects the thought that a currently operating lease has value, and it is regularly reviewed to reflect market conditions, and it is updated when needed. If a well is shut down for part of the year, or if gas prices are particularly low for a year, the mass appraisal method can result in a number that is less than fair market value, and that is when the minimum leasehold value is applied as directed by the guide. Because this is mass appraisal of tens of thousands of wells at one time, one single formula will not reach fair market value for every single property. These wells are currently producing, they are not expressly exempt from property tax, and as such, they have value. The minimum leasehold value is only applied after the general formula does not reach fair market value. It is not arbitrary or unfair because working property has value, and in a mass appraisal system, we have to account for that value. The minimum leasehold value is a necessary and reasonable part of the methodology. Additionally, and quite importantly, there is a fail-safe in place to make sure there is another way to reach fair market value if it is determined that the minimum leasehold value also did not get there. The legislature saw fit to provide flexibility by creating a deviation rule in KSA 79-1456 that allows the appraiser to deviate from the guide-produced values on an individual lease for just cause. All of these methods, they work together in harmony. They do not work in individual vacuums. The Court of Appeals did not mention this deviation rule in their opinion, but it is this rule that helps to ensure that the minimum leasehold value is not arbitrary and capricious.
Counsel, I've got a question about this. So if the minimum leasehold value, if is challenged as to a specific lease, then this fail-safe goes into place, is what you're saying, and the appraiser or the owner of the lease can try to arrive at fair market value, correct?
Yes, Your Honor, that is correct. So the burden of proof is on the taxpayer, and if they believe that the minimum leasehold value as applied does not reach fair market value, then they can provide additional information to the county appraiser, who can then consider that information and apply the deviation rule if it is warranted.
And does the statute restrict what information can be presented during this fail-safe process in trying to arrive at fair market value?
No, it does not. The taxpayer can provide any information that they think that would help the appraiser make a determination.
And was this fail-safe process used on each of these 203 leases that are at issue here?
It was not, Your Honor. So the taxpayer, they did provide the bankruptcy sale information, which did happen after the valuation date, but they didn't provide any other additional information in order to give the county appraiser the information that they would need in order to deviate from the guide values. Additionally, the guide directing the use of the minimum leasehold value takes into consideration all statutory factors, including consideration of expenses. It is important to remember that the oil and gas guide is a mass appraisal tool using average rather than actual expenses, and it is using market averages, statistical data provided by the federal government, and information provided by industry professionals. Every year, the Property Valuation Division of the Kansas Department of Revenue hosts meetings with stakeholders to help determine values and market trends. These meetings are attended by producers, county appraisers, geologists, tax professionals, attorneys, and even the occasional royalty owner.
Counsel, can I interrupt you there and probe into that a little bit? Doesn't the fact that of what you just described, that the guide produces average values as opposed to actual values, isn't that almost sort of an admission that these are fictional values?
Well,
and the statute expressly prohibits that.
No, Your Honor. If you look at the city's case that is cited in the brief, it talks specifically about the fact that we have to use mass appraisal in the state of Kansas. Because if we were to look at individual property, we have over 1 million parcels in the state of Kansas that have to be valued at one time. If we were to look at each individual piece of property, that's the ideal way to value property. However, this court has ruled in the past that that would be so cost prohibitive as to be confiscatory. And so using mass appraisal is not necessarily going to create a result on an individual piece of property that's indicative of 100% of its value. The idea is we try to get as reasonably close as we possibly can, which is why we have the deviation rule in place, so that if there is something that's atypical, so we are looking at typical, right, wells or leases. And so if there is an atypical situation, right, we have that deviation rule to make sure that we do get to fair market value. And this is not the only place where we use averages.
And so is that essentially an admission that it is simply impractical to, quote, reach the actual fair market value, and that basically you're relying on Supreme Court precedent that permits you to sidestep that statutory requirement?
Chief Justice, I see that I am out of time. May I answer the question?
Yes, certainly.
So it's not so much that it's impractical, it's nearly impossible, Your Honor. So we use
I guess I'll just ask, is that an admission that you are not you personally, but the state, the appraisal system is not reaching actual fair market value.
That is correct. And if you look at that city's case that's cited, it talks specifically about that and how the mass appraisal system and the idea is to get as close to as possible, but that value is not necessarily indicative of any one individual piece of property. That is correct.
But as I understand it, that's why you have the fail-safe process.
Correct, exactly. And so if, like I said, if the taxpayer or the county appraiser believes that the guide produced values, which includes the minimum leasehold value, does not reach fair market value, then the taxpayer can provide additional information, whether that be their actual expense information or anything else that would provide information to the county appraiser to suggest that they are in an atypical situation. Then the county appraiser can take that information into consideration and deviate on an individual lease for just cause. That is correct.
Council, so under that deviation or safe procedure, the taxpayer has to establish good cause. So when the minimum lease value is applied because actual working costs exceed that 90% threshold, is that enough to establish just cause?
It's going to have to be very individual, but if they provide their actual, if they provide their actual expenses and there is something atypical about them, that's at least going to give the appraiser the ability to make that determination. But it's going to be very fact specific on any individual lease, and the appraiser is going to have to use their professional judgment to determine whether or not the information provided by the taxpayer reaches that threshold that they need to get to deviate.
So something beyond just the mere application of the minimum lease value being applied in that schedule would have to be shown to establish just cause?
Yes, that's correct, Your Honor.
There are other questions? Thank you, Ms. Wood. Mr. Wolford?
Thank you, Your Honor. First of all, I'd like to address the proper subject matter scope of this case. At the county level, River Rock prosecuted appeals for exactly 2,183 wells. The counties denied those appeals because there wasn't property-specific information sufficient to justify a deviation from the guide values. So River Rock then filed state-level appeals, protest appeals for exactly 206 of those wells, and paid the required filing fee for each of those wells. That same day, the company filed a motion for consolidation and fee abatement. And in its motion, River Rock confirmed that it had perfected protests for 206 wells and had not perfected protests for the other wells. In its motion, River Rock also expressed a desire to perfect appeals for the other wells, that is, if the fees were abated. So then 10 days later, BOTA issued its notice of filing, assigning docket numbers to the 206 appeals that were actually filed and perfected at BOTA. Then in July 2017, BOTA issued a consolidated order on River Rock's motion to consolidate and abate filing fees. And the order was issued under the 206 dockets identified in BOTA's notice of filing. No other properties were mentioned in that order. River Rock stood silent as the 206 dockets proceeded from docketing to discovery, and then ultimately were decided on their merits approximately a year and a half later. To be clear, BOTA never dismissed, any of River Rock's protests and never refused to docket anything. BOTA simply docketed the appeals that were actually filed and perfected. There's no statute or regulation that permits a taxpayer to perfect a BOTA appeal by filing a motion that expresses a conditional desire to protest.
Counsel,
Yes, yes, sir.
Counsel, the Court of Appeals seemed, at least to me, to rely on the language, excuse me, in Boda's order that the appeals referenced in the motion shall be consolidated. And it seems as if, at least on its face, that rationale has merit, because the appeals referenced in the motion are all 2000 whatever appeals.
And I understand that. There were, as I recall, there's a reference in the motion to the 206 appeals that were properly perfected. And that was an Exhibit A or Exhibit 1. And then the others that they expressed a conditional desire to appeal if Boda were to waive the filing fees or abate the filing fees. That was in Exhibit 2. So it was perhaps inartfully worded, but the consolidated order was issued under the 206 dockets.
Well, why wouldn't that River Rock have potentially just thought that they had gotten a consolidation of all 2000 appeals?
Well, if all 2,183 appeals had been consolidated, that would be the docket numbers listed on the caption. 206. There were only 206 on the Boda caption, and they received a notice of filing in March, 10 days after they perfected the appeals, the 206 appeals that specifically listed by name, lease, county, the 206 appeals that were filed. I understand that. Yes.
The Court of Appeals says that at best, what you just described, the number of the docketed appeals, at best, this can only be loosely inferred from the caption. And since we're talking about a jurisdictional question about when the 30-day time runs for an appeal, I guess my question is, what's your best argument for why the 30 days should run when we have this, as you put it, inartfully worded order?
Oh, okay. I don't think the inference is at all loose, that the caption lists every docket number, 206, and those are the exact 206 that were filed, notice of filing, and those are the exact 206 that River Rock references in its motion that were perfected. So I don't know if I agree that there's a loose inference here. And I guess it's important also to recognize that at best, this was agency inaction. There was no reference, they didn't address those 1,000, or the Boda didn't address those 1,977 other appeals. Nowhere did they take an affirmative position on those cases. They just didn't take any action, appropriately so.
Then how can it be a final order triggering the 30-day time limit? If they said nothing, how can it be a final order?
An order is only one type of action, agency action. There was agency inaction. An agency inaction is appealable after 30 days when it becomes clear, and it became clear at least by July 2017 that there were only 206 wells on this docket. And then the business about the $25 abated filing fee. There was no overpayment, underpayment, confusion about what fees covered what wells, as was suggested. There's no flat $25 abated fee for oil and gas property. That's real property. Though the $25 flat abated fee applies only to parcels, real estate parcels. Oil and gas properties aren't real estate parcels. River Rock paid exactly $150 to perfect 206 protest applications. 150 times 206 wells is $30,900. So River Rock didn't file or perfect protest applications, admittedly, they admitted that, or pay filing fees in full or in part for any of the other wells. So to the substance of this, is $150 per well filing fee too high when by statute adjudicating an oil and gas valuation appeal requires analysis of property specific data on an individual well? I don't know. That's a question for lawmakers, not courts. But the upshot here is that this case has always been about 206 wells, not 2,183 wells. And judicial review must be limited to the 206 wells that were properly filed and perfected at BOTA. And I think the record's clear on that. Thank you, Your Honors. If you have any questions.
Doesn't appear that there are any questions. Thank you, Mr. Wolford.
Thank you, Your Honor.
Mr. Brock?
May it please the court? I'm sorry, I was just waiting for the timer to get right, Your Honor. I think the place to start would be to clarify what issues are before this court. There were 4 issues originally before the Court of Appeals. One of those issues being the value imputed to the saltwater disposal lines on line 8B was ruled upon by the Court of Appeals, and no party has challenged that ruling. So it's our position that that issue isn't in front of this court and should just be affirmed. The other 2 issues, the first of which is the minimum lease value that you've heard about from PVD. The second of which is the value of personal property, tangible equipment on line 8A of the rendition. And then the final issue is the abatement of the filing fees and the docketing of those 2,000 appeals. We'll address issues 1 and 2, primarily focusing on issue 1. If we have questions about the filing fee issue, I'm happy to answer those, but I feel that that's adequately briefed, and the Court of Appeals did a great job of analyzing that issue. And so I probably won't focus too much on that. As it relates to the minimum lease value, I think it's important to have a little bit of background. So River Rock purchased 2,150 wells in 2006. They paid a little over $1.7 million for those wells. After they bought them, they discovered that the counties had collectively appraised them for $13.5 million, a little over $13.5 million. When they tried to figure out why that was, they discovered that all but 56 of those wells had been assigned arbitrary minimum lease values by the counties. And on further review, they discovered that the Property Valuation Division appraisal guide mandated that that minimum lease value be applied. And it's our position that that provision, that minimum lease value provision, is as a matter of law invalid. Kansas statutes set forth 3 mandates when valuing these wells. First, that only wells producing or capable of producing and paying quantities are taxable personal property. Second, that 8 factors must be considered when valuing these wells. And third, that we have to use the actual true fair market value and not some arbitrary artificial value. And it's River Rock's position that when a minimum lease value is assigned, by definition, that's an arbitrary artificial value. The other issue is that when you apply a minimum lease value, you necessarily disregard some of the factors that the legislature has mandated be considered, because it disregards a portion of the operating costs attributable to the wells. If you follow the guide through in the rendition, the primary appraisal method is a discounted cash flow appraisal method. And that's important because that's the same method that is used by the industry and is used by petroleum engineers and everyone else in the industry. And that is done through line 5 on the rendition form. Basically, you're calculating the value of the income stream, and through that, you're determining the value of those reserves in the ground.
Counsel, let me, I
Yes.
want to make sure we have time to focus on this. I don't understand your statement that says that the wells are required to be valued at the minimum lease value because every lease can be addressed if the taxpayer believes that that minimum lease value isn't accurate, correct? That's the fail-safe thing we were talking about.
So you're talking about the ability to appeal if just cause is shown to deviate from the guide?
Yeah, I mean, that's the system. It's
So-
in the law.
Yeah, so our position on that is that the state cannot violate Kansas statute in the manner in which they do the appraisal and then put the burden on the taxpayer to come forward with property specific evidence. In this case, the statutes, they mandate how they have to be appraised. And the guide sets a minimum lease value contrary to those statutes. And so as a matter of law, that practice is incorrect. And Garvey Grain v. McDonald specifically creates a remedy for a taxpayer to contend that as a matter of law, the guide is unlawful as it's applied to a taxpayer's property. And that's what we're arguing here. As a matter of law, this minimum lease value is unlawful. And when you talk about the fail-safe, what that really is it's a complete burden shifting. The case law mandates that a proper and lawful appraisal is a necessary first step to the assessment of property taxes. So before that first step, or before the tax can be levied, that first step has to be done. And here we don't have that. We don't have a lawful appraisal that's conducted. Instead, we have an arbitrary minimum lease value set, and then in my client's case, a burden to come forward and prove on a well by well basis for 2,150 wells that arbitrary minimum lease value is incorrect.
You're talking about a mechanical burden as opposed to a legal one. I mean, the law just says just cause, but the law also requires the property valuation director to create these guides and to use them. And it sets up this system. But the system has this fail-safe mechanism that says if you don't like the value that you get to go in and litigate it. I mean, or have a meeting with the county appraiser in order to come to a decision.
And at the county appraisal level, my client was told in every one of these counties that they don't have the ability to deviate from the minimum lease value because that's mandated by PBD.
But but the law doesn't say that. And so where is that in the record that the county appraisers in these three counties were violating the law, the procedural setup of the law? You're saying that your client could not come in and present evidence as the statute provides. That's a whole different problem.
I'm saying that my client did not have the legal obligation to do that.
That's a different question. What you said earlier was that they were told that it was a mandated value and no one could move off of it. And that's not what the law says.
I think that when you ask for the authority, I think what the authority is that we would rely on is that a proper appraisal is the necessary first step. And so if you don't have that first step, then the assessment itself is void as a matter of law. And that's what we're contending. Why
can't this guide that's put together by all these experts and updated and periodically as it is, why can't that be substantial competent evidence as to what the value is, subject to the taxpayer coming in with real information?
So in any appraisal, the appraiser is required to use the practices that are accepted by the industry. And the evidence presented here is that no industry participant or other governmental entity accepts this minimum lease value or the assumption that these wells cannot have zero or negative value. The evidence is that every other industry participant and governmental agency recognizes that these leases can have zero value or negative value. And in practice, they do. I've been involved in a lot of transactions where the seller pays the buyer to take these properties. It can't be, we can't use an example of a commercial real estate or even real property in general, because these assets are located thousands of feet under the ground. And regardless of where any of us are sitting, there are measurable quantities of oil and gas. But unless they are economically recoverable, they have no value. And here, these reserves, if they are not economically recoverable, they don't have a value, making the value zero. And that's what industry participants and governmental entities recognize. And so that's where the guide departs, because they're the only.
At the BOTA level, you presented evidence that you're just talking about, right?
Correct, yes.
And there was other evidence that the property valuation director put on, and of other kinds about why the guide is valid, right?
So the only evidence that they put on was that in 1969, Professor Weinog believed that that should be included, and that minimum lease value has been included since 1969. There was absolutely no evidence presented that any other industry participant or government agency does this. And there wasn't even, the only justification provided was that as the production continues, expenses tend to level out. But that doesn't mean that they continue to produce profitably forever. So I would say no, they did not present any evidence to justify that practice.
Counsel, as I understand it, your position is very boiled down that Kansas law requires appraisers of these wells to aim at actual fair market value. Is that correct?
To aim at, you're exactly right, Your Honor.
And does that obligation, under your understanding of the law, does that attach to the appraisal process before or after a taxpayer protests?
Before. They must aim at that. They must conduct the valid appraisal before taxes can be levied.
Okay, thank you.
Yes. And I think the guide, with the exception of the minimum lease value, the guide does a good job of aiming at that true fair market value. When the minimum lease value is not applied, they have these schedules that really go into great detail to try to outline what costs a well would incur in operating it. But the difficulty is that when the minimum lease value is applied, those are completely disregarded. And instead of using that good faith estimate of true market value, the guide just says, we're just gonna attribute 10% of the gross value of those reserves in the ground. That's not an attempt to reach fair market value. That's an arbitrary valuation. And so that's, in the testimony before BOTA was that every other industry participant or government agency, they include all of the costs of operation, even if that renders the value zero. And so these good faith estimate of expenses, they need to actually be used. And I think that that's clearly what the Kansas legislature intended when they mandated that cost of operation be used to value the wells. They intended that there be a good faith estimate as to those costs. And that doesn't happen when the minimum lease value is used. If you look at the evidence presented before BOTA as to the invalidity of the minimum lease value by both Michael Begland and Jay Jimerson, expert witnesses, versus what the counties and PVD presented, it is overwhelmingly one-sided. The only justification for including this minimum lease value is that the original author thought it was appropriate and that they continued to do that since 1969. There's no current evidence that that produces a fair market value. And in fact, the evidence shows that it doesn't. It inflates the value. And the intent to inflate the value is evidenced even further because line 7 of the rendition requires the appraiser to use the greater of the two values, either the minimum lease value or the value produced by the discounted cash flow. And when you have a step where the appraiser is required to choose the greater of two values, obviously the intent is to produce an inflated and higher result, not to reach the true fair market value. Otherwise, that appraiser would be empowered to consider the facts surrounding that property and try to determine true fair market value. But instead, we have a mandate to choose the greater of the two values. The other issue that's involved is the value of the equipment on lines 8A. That consists of some tangible personal property, pumping units, tubes, rods, etc. The Court of Appeals analyzed this issue. This is the issue that was preserved in our conditional cross petition for review. We think that the Court of Appeals got a good grasp on the argument, but we think that the conclusion reached on that particular issue wasn't correct. Essentially, what's happened is that all 2,150 of these wells were drilled at the same time, designed by the same operator, and include the same equipment. And so the evidence presented about the value of this equipment applies to all the wells, not just wells that were plugged, but all of the wells that are the subject of this appeal. And the evidence presented was that River Rock has had to plug several of these wells because they're not profitable, and that they've tried to sell this equipment. And they've contacted every single buyer that they can find, and no one is willing to buy this equipment. The evidence has also shown that the cost of removing this equipment from the wells and completing the statutory obligation to plug the well far exceeds the value of this equipment. And so it's our position that that equipment does not have a positive value. One, because River Rock hasn't been able to sell it to anyone, and two, the cost of removal and plugging the wells, which is required by law when that equipment is pulled, exceeds the value of the equipment.
What's our standard of review on this question? Because as I read it, the Court of Appeals basically said, hey, this could have gone either way. The evidence below was, split, let's just say, and we're not going to second guess BOTA's weighing of the evidence.
Yeah, your standard of review on the issue is de novo. And the reason that it's de novo is because this case was presented to BOTA entirely on pre-filed written testimony and exhibits. And the case law indicates that when the question is presented based on written documents and exhibits, that the standard of review is de novo. There was no opportunity for BOTA to weigh witness testimony or anything beyond what the.
So aside from re-weighing the evidence, is on appellate review, I presume we consider the evidence in the light most favorable to the prevailing party below. Would you agree with that?
Since we're the ones alleging that the agency made an error, we have the burden to show that the agency made the error under the Kansas Judicial Review Act. So I would agree with that, yes.
Thank you.
And
let me get back to the mass appraisal methodology. Is it your position that it just can't be utilized and each specific well must be subject to an individual assessment, or that it just requires some adjustments in the methodology?
No, a mass appraisal approach is perfectly fine, and we agree that that's appropriate and practical. It's just that the minimum lease value line item in the rendition, it causes the result to be contrary to what Kansas statutes require. And Mr. Beglin and Mr. Jimerson, the two expert witnesses at the BOTA level, they testified that if we remove that line item, that rendition will produce an accurate appraised value for these specific wells. It wasn't just a blanket opinion testimony. They went on to say that the values for these wells will be more accurate with that line item removed.
Thank you.
And it's important to note that the issues as it relates to the minimum lease value are different than the issue related to the 8A equipment. Because the minimum lease value, we're arguing that as a matter of law, that minimum lease value is incorrect as it applies to River Rock's property. As it relates to the equipment valued on line 8A, we're contending that the county should have deviated from the guide tables based on evidence actually presented. And that's the fail-safe. For the tangible personal property on line 8A, we agree that the way the guide goes about trying to value that is fine. But as it relates to River Rock specific property, it produced a higher value than what we actually see in the field. And so we presented evidence to try to show that that should be deviated from. So it's important to separate those two issues, because we're not arguing that the guide should have been deviated as it relates to the minimum well value. We're arguing the minimum well value wasn't appropriate.
But explain that a little bit more to me, because why couldn't you make the argument that applying the minimum lease value or your request not to apply it is a deviation? Why wouldn't it be a deviation?
Because for every well where that minimum lease value is actually used, for every well where that minimum lease value is higher than the value arrived at when using the discounted cash flow analysis, the well is appraised at a manner that's inconsistent with Kansas statutes. It's appraised at a manner that does not strive for fair market value. It's appraised at a manner that doesn't fully consider all costs of operation. And so as a matter of law, the use of that provision is invalid. And further, the evidence has shown that the use of that practice is completely inconsistent with any industry practice, and that it's based on an assumption that's not supported by the record in this case, that all producing wells have value. And that's simply incorrect. When they started with the false assumption, they reached a false result at the end. Does that answer the question?
I think so. It's your position is it's the methodology itself, by including that minimum lease valuation, is flawed in terms of arriving at fair market value, as opposed to a specific deviation that you might request under an established and acceptable methodology.
Absolutely correct, Your Honor. That's absolutely correct. I see that I'm out of time. If anyone has any other questions, I'm happy to answer them. But
any other questions? Doesn't appear that there are any. If you'd like to summarize your request.
Oh, yes, Your Honor. We would ask that the Court of Appeals decision as it relates to the minimum lease value be affirmed, that the Court of Appeals decision as it relates to the equipment value on line 8A equipment be affirmed, that the Court of Appeals decision remanding the case to BOTA as on the basis of the filing fee abatement issue be affirmed, and that the Court of Appeals ruling on the issue of the line 8A equipment be reversed.
Thank you, Mr. Brock.
Thank you.
Ms. Woodard, you reserve 3 minutes.
Yes, Your Honor. So, Your Honor, Mr. Brock talked about how the discounted cash flow method is the industry standard. Well, the discounted cash flow method that's in the guide, it looks similar to what the industry professionals do, but it differs in significant ways. And first of all, before we even get to the minimum leasehold value, the value that we're looking at has already accounted for the declination rate, the time value of money, the location and types of wells, and every other factor. So when we get to the minimum leasehold value, what we're looking at is the expenses. And what it takes into consideration is that in a typical situation, as production declines, expenses tend to flatten out. And so because unlike the industry, we don't have their actual expenses and we're using averages, that's why in 2016 that it was capped at 90%, right, of that value. And I'd like to point, I mentioned cities earlier, and I should have said what it was actually Appeal of Horizon Telecommunications is the case that I was trying to point you to, where the Supreme Court here in Kansas upheld mass appraisal because it would be confiscatory to do otherwise. And it says, and I quote, "Some appropriate method of mass valuation must be utilized, even though individual inequities will result." And so the minimum leasehold value, right, it takes into consideration the expenses. It takes into consideration typical, right, well production. And then we have the deviation rule in the event, right, that there is something atypical about that. There's also the issue of the equipment values in the guide. The Court of Appeals was correct when stating that the equipment has value because nothing in the record suggests that the wells would not be profitable if the price of natural gas goes up, or that the equipment would not be suitable for use if market conditions improve. This same logic should also be applied to the value of the working leasehold interests. Nothing in the record suggests that the leases would not be profitable if the price of natural gas goes up or if market conditions improve. The Kansas Department of Revenue prays that this court will uphold the order of the Board of Tax Appeals and rule that the minimum leasehold value is a valid part of the appraisal methodology and that the equipment values in the oil and gas guide are fair and reasonable. If you have any further questions, I'm happy to answer them at this time.
It doesn't appear that there are any questions. Thank you, Ms. Woodard.
Thank you, Your Honor.
Mr. Wolford?
Yes, Your Honor. I think it's important to realize the guide is only a starting point. So it's also the end point for most properties because the vast majority of taxpayers accept the guide's robust allowances and market-based benchmarks and formulas. But if the taxpayer is not satisfied with the guide valuation, the deviation rule always applies. So the minimum lease value provisions don't always do anything, as was suggested by the Court of Appeals. If these wells are truly worthless or have negative values, then what are they doing out there? An oil and gas lease cannot be held by a well that is incapable of producing in commercial quantities. These have value. And as the Department of Revenue has explained, they've conducted statistical analysis. They've looked at industry data. They convene every year a group of experts on both sides, industry and government, to make sure that these are proper and valid and reflect value, the market value. So to say that there's really no evidence or that this is arbitrary is really not a fair statement. And the evidence that was presented also, it's important that, River Rock did present a number of, points. We budgeted a certain amount of money to plug some wells. Leases can and often do have minimum negative or zero values. Well, that doesn't get you there. The law requires that BOTA apply the guide value and accept that as prima facie evidence, unless under 79-1456 the taxpayer comes forth with individual property data. The counties don't have access to individual property data. River Rock certainly has access, and if they, for whatever reason, they didn't produce it in discovery, and they didn't present any evidence at the trial, or not at the trial, but at the proceedings. So, and as far as whether it takes into the allowance takes into consideration all of the costs, it does. The amount of cost may be in dispute, but that's a fact issue, and you have to address that on an individual property basis per statute. Thank you, Your Honor.
Counsel, let me ask you, I understood Mr. Brock to say that your clients refused to comply with 79-1456, which is the fail-safe mechanism of refusing to consider individual data, that they were mandated to take the minimum lease value without any deviation. Is there anything in the record that indicates that? One way or the other?
Your Honor, not only is there nothing in the record, I've asked that question before, and I've received an affirmative no, that did not happen. But no, there's nothing in the record that suggests that.
Is the objection to line 7 in section 6, the parenthetical, whichever line is greater, is that a request for deviation for good cause that would be considered in the safety valve or the 1456 provision?
No, Your Honor. What that does, the minimum leasehold, it's an allowance. It's an expense ratio where as with any operating property, production declines, you tighten up your expenses. So as a model, the evidence shows that the market evidence shows that the value tends to be around, the 10%. That doesn't mean it always is, but that's what the model says, and the counties don't have any of the actual information. So if they want an actual value, or they need to provide actual costs, or they can provide their internal reserve information. They have to provide something on an individual property basis. They just can't disagree with the legislative facts found by this group of experts that meet according to a statutorily prescribed process. So no, I mean, it takes individual property information. They have it, government doesn't.
Counsel, I'll follow up and ask you the same question asked Mr. Brock. In your view, does the obligation that the law imposes on the appraiser to aim at actual fair market value, does that attach before or only after a taxpayer objects?
It attaches from the very beginning. And
so if an appraiser violates that, then that's a violation regardless of whether the taxpayer objects or not, correct?
The guide value is prima facie evidence.
I understand you disagree with the premise that you have ever, not you, but again, the counties or the state has ever not aimed at fair market value. But what I'm trying to drive at is I just don't understand how, if the River Rock is correct that the minimum lease value violates the law, I don't understand how a so-called fail-safe that comes in after the fact could change the fact that the state has not performed a legal valuation in the first place.
Certainly, if that provision violates statute, which it doesn't, or if it's arbitrary, which it isn't, then yes, I mean, you can strike it it's a facial challenge, and you can strike.
Okay,
that.
so you stand on the merits of the argument as opposed to a sort of fail-safe claim.
No, I think the fail-safe claim is the linchpin of this case. A model can't be arbitrary if it provides an opportunity to address every single situation differently. It just shifts the burden.
Are there other questions? Thank you, Mr. Wolford.
Thank you,
Thank you to all counsel for your arguments today. The court will take this appeal under advisement. We are now